Thank you. For the record, Darrell Perry, CEO of Lobby LLC. And most of what I was going to say has already been said and was also said last year during the hearing on HB 372. Again, the wording here is identical to what 372 was before being amended by the Senate. Just want to reiterate that if this passes, as was mentioned, there would be confusion for snowbirds because RSA 259-88 states, quote, resident shall mean a resident of the state as defined in RSA 21:6, which this seeks to amend, except that no person shall be deemed to be a resident who claims residence in another state for any purpose. Let me give an example of a couple of friends of mine, married couple. They live in New Hampshire for about half the year and then snowbird down to Florida. The husband claims residency in New Hampshire. The wife does not. If this passes, then it seems to me that maybe the wife might be forced to claim residency in New Hampshire while she's here, even though she claims it in Florida, and 259-88 says that you can't force someone to be a resident if they claim it elsewhere. Same thing with college students. Most of the college students that are not from New Hampshire will claim residence somewhere else because they do intend to leave at some point. If this passes, it would either force them to claim New Hampshire as their residence, which would then qualify them for in-state tuition, or because they would still be domiciled, but they would not be New Hampshire residents because they claim it elsewhere. So again, it just seems to create a lot of unnecessary confusion. So I would urge the committee to ITL.
Thank you. Questions from committee members for Mr. Perry?